That's what we're going to use. Is
All time. For the most part.
Okay, I can oil change here.
I know.
Yeah.
Good afternoon, everybody. My name is Bruce Harrell. I'm chair of the Public Safety, Civil Rights, and Technology Committee. I'm joined by capable and competent council members Nick Licata, Gene Godden, and Sally Bagshaw. I do want to announce that Councilmember Bagshaw has a conflict at around 2:30 on the Center City Initiative, so she's going to excuse herself. Thanks for doing that work offline. We have a lot of presenters here today to have this robust discussion, so I'm going to stall for a minute until we get our seats straight. I'm going to start off with a brief chair's report, and then we're going to dive into a discussion. And I think all of you have sort of a document to sort of guide us through the discussion topics. Public comment will be at the end of the session. I did solicit many comments from the public prior to this. I think we know what questions need to be asked, but again, if there are many more, we will have comment after and continue to do the work. I passed out another document that, with respect to Chief Bailey's decision, which has gotten some level of scrutiny, I passed out a document, the municipal code, that talks about whenever, it's 3.28.812, that whenever the chief makes a finding that is different than the finding of the director, what he or she hypothetically are supposed to do. In this case, it was done, and that would be a letter that goes to the mayor and to the city council with a written explanation as to why there was a disagreement in the finding, the earlier finding. And I wanted to point out, before we dive into the discussion, that this happens with some level of, I don't want to say consistency, but in last year we had several cases like this where we had a former chief of police Pugil send a letter to the council and to the mayor describing why a training referral, as an example, was better believed to be the right course of action. And so this is not an unprecedented situation. And when we get to how do we bring more attention to this issue and what process changes we may, I'm going to ask central staff we're going to talk about this at the appropriate time. We'll talk about what that can look like. Should the director, should the OPA director, or the auditor, should the CPC, all these folks be notified in that process? So that's just an opening comment on where we want to head in this conversation. So without further ado, why don't we start out with name introductions first for the viewing audience, and I'll come back and probably introduce our deputy mayor. There's some other work that we're going to be doing that I think the mayor would like it described, and I'll give you that opportunity to do so. So why don't we just start off with name introductions, and I'll loop back, please.
Dan Eder, Council Central Staff.
Hyeok Kim, Deputy Mayor.
Tina Podladowski, Senior Policy Advisor to Mayor Murray.
Fed Lopez, Acting Director of the Community Police Commission.
Pierce Murphy, OPA Director.
Susan Koski, Director Personnel.
Harry Bailey, Interim Chief of Police.
Rennie Bispham, Legal Advisor, Seattle Police Department.
Jean Bowlers, Civil Division Chief for the Seattle City Attorney's Office.
Pete Holmes, City Attorney.
David.
And okay, and we've been joined by Council Member Sally Clark and Council President Tim Burgess as well. And
David Brosnow, Director of Labor Relations.
Thank you, David. Before we tee up the discussion, I've been advised we should at least read the first matter into the record.
Seattle Police Department Disciplinary Review, Office of Professional Accountability Process.
And before I turn it over to Deputy Mayor, I did want to acknowledge we have several other vested members, including our auditor and CPC representatives, monitoring team representatives, police accountability advocates, community members, and everyone else here listening to this discussion. So I want to acknowledge that we have a lot of vested and interested people in the discussion. Deputy Mayor, please share with us a few ideas that you have.
Thank you so much, and thank you, Chair Harrell, members of the committee. I also want to say thank you for allowing me to read a few prepared remarks. I think given the complex nature of this issue, I wanted to make sure that I did not misspeak, and therefore, if you will indulge me in some written prepared remarks, I would appreciate that.
Sure.
So Thank you again for having this opportunity in a very public and transparent way to have this discussion today. I want to start by acknowledging the considerable confusion that this issue has generated for the council, for the press, for the police department, and for members of the general public. The mayor has assumed responsibility for this confusion, as you know. And while the mayor did not play a role in designing the overall context in which this confusion is taking place, the mayor will play a role in helping to redesign and reform, along with all of you, this context in order to eliminate the potential for this kind of confusion from occurring again in the future. And so along these lines, I want to reiterate today the mayor's commitment to police reform in general, and in particular to the issues of transparency and accountability that the Marion case and the 6 additional settlement agreements have brought forward in recent days. I'll touch briefly on these cases before turning, with your indulgence, to the broader and more difficult issue of an OPA complaint, investigation, discipline, and grievance process, which is outdated and overly complicated, and which lacks not only transparency, but reasonable timeframes and any natural or predictable endpoint. In the Marion case, Chief Bailey has said that it was not his intent to overturn the misconduct finding determined by the OPA. Rather, it was his intent to impose a progressive form of discipline that would help shape the kind of behavior the public and the department expect from our SPD officers. But his actions to impose such an alternative form of discipline, Chief Bailey, with the consent of the mayor, did in fact overturn the misconduct finding. Additionally, I want to note and be very clear that the law department did not have the opportunity in the Marion case to provide recommendations to Chief Bailey nor to the mayor's office. And because we can clearly identify where our checks and balances broke down, and because the resulting reversal of misconduct was not what the chief had intended, this past Monday, the mayor and the chief reinstated the original finding of misconduct. You are also aware that there were 6 additional cases in the arbitration pipeline for which Chief Bailey finalized settlement agreements in order to avoid arbitration. These cases date from 2010 and 2011. I also want to be very clear, especially with our partners from the law department here, that while there was a memo in which the law department provided not one consistent, but a variety of different recommendations, as well as identification of options to consider, we have not been able to the mayor's satisfaction, been able to determine at what point during this past fall the SPD leadership gave clear and concise signals, and the manner in which they gave that signal that those settlements ought to be approved. And because there was that lack of documentation or transparency, Mayor Murray, in consultation with the Federal Monitor and the Department of Justice, has agreed that the next best step is for Mayor Murray to ask Barney Melekian, his special advisor on public safety, to revisit these 6 cases in the following manner. He would like to convene a group, he would like to ask Barney Melekian to convene a group consisting of representatives from law, labor relations, the police department, along with input from our Federal Monitor and the U.S. Department of Justice, to provide a more thorough and critical review of all 6 cases. These cases, as we know, are important. And we know that it's important for us to make sure that the outcomes are fair, that they send the right signals to the department and to the public at large, but most importantly, for the people involved in these cases, the complainant and the officer. And therefore, with certain haste, Mayor Murray will be asking Barney Melekian to reach out to all of those named parties to be able to work as speedily as possible to do a more thorough vetting and understanding of the decisions that were made in those 6 cases. And I also want to just say thanks to the law department for their patience with us as we have been sorting out the rather complicated paper trail or lack of paper trail in this decision-making process. But we also have to focus our needs on in a broader context. We already know that the OPA complaint, investigation, discipline, and grievance process is flawed and needs to be reviewed. And so that's the work we are going to undertake. In order for us to be able to conduct such a review with transparency, however, the mayor has asked, and the chief agrees, to place an indefinite hold on any further actions that could result in any potential settlement of any outstanding grievance where an OPA finding of misconduct has been determined. And I know in our previous visit with city council members, there was a question about that. I think someone else, as far as the universe of outstanding cases, and we have representatives to speak to that later if you want to ask. Additionally, I just want to say that, as some of you may know, the OPA auditor sent a letter to the interim chief Bailey on Monday requesting the opportunity to look at various aspects of the OPA process. We welcome and embrace such an opportunity. In addition, the Community Police Commission will be offering initial recommendations at the end of March for improving the OPA process. And in the last few years, Councilmember Harrell, as Public Safety Chair, has also raised issues and concerns about the OPA process. In fact, so have SPD, the OPA Director, and even the Seattle Police Officers Guild. On this, we can all agree our convoluted process, and actually 3 processes, requires review and more. So Mr. Melekian will initiate and lead a broader group to take a look at and unpack and address comprehensively the complaint process, the investigation and discipline process, the labor review process, and the appeals and settlement process, incorporating both previous recommendations, the current CPC work, and any other further recommendations that may come from the OPA audit referenced before. In fact, the overall OPA process was initially designed to address major complaint issues, and many questions remain, like how can we better classify and categorize discipline in order to address the regular workplace issues in a much more expedited manner for the complainant and the officer? How can we make the complaint process easier and faster for everyone? How can we make sure that the integrity of an open OPA complainant and investigative process is not jeopardized nor undermined by the closed labor review, appeals, and settlement process, and so on? And so Mr. Melekian will conduct this effort with law, with labor relations, SPD, the OPA Director, the OPA Monitor, and the CPC in consultation with the Federal Monitor and the DOJ. And certainly, we will also invite and welcome our City Council members as part of that process. In addition to the 6 cases we've discussed today, or I've discussed today, we know that there are 10 cases that were recommended for arbitration. There are also 5 additional grievances from the union. And again, as I mentioned earlier, all cases pending settlement will be placed on indefinite hold while we conduct this process review. In closing, I want to state for the record that the mayor will be sending a letter to the monitor, the DOJ, Interim Chief Bailey, the OPA Director, the OPA Auditor, the Law Department, Labor Relations, and the CPC to memorialize much of what I have discussed here, and we will certainly carbon copy our City Council members as well. So, with that, thank you again for the opportunity to share some opening remarks, and all of us are here at the ready to answer your questions. Thank you.
Thank you very much. I have a question. I know Councilmember Licata has a question or a comment, and I would like the participants at the table to remember what's coming next. And what's coming next is Tina Polodowski sort of walking us through the chart, explaining sort of what happened, the existing process to the extent obviously will be changed. Thanks for those opening remarks, by the way. Those are very helpful. And we'll sort of find out exactly what happened before we get into how it needs to be changed. And so that's next. Having said that, the one question I have is, you did indicate, Deputy Mayor, that Barney Melekian would be reaching out to all of the parties relative to these 6 cases. And so by that, I'm assuming you mean the complainants and the officers, and who are the parties that you're referring to?
Representatives of the law department, Interim Chief Bailey, obviously, as head of the SPD, our labor relations representative, and in conjunction with the federal monitor and the Department of Justice.
Yeah. One element that seems to be missing, again, in the existing process, again, is the involvement of the complainant itself. And so, again, we're going to talk more about that, but that's an important voice sometimes that I think gets overlooked. And I did want to say that Barney Malekian was invited to be here. He had a scheduling conflict, and so he could not be here, but he was scheduled to be here. So, Councilmember Licata.
Great. Thank you, Councilman Harrell, our chair. I want to thank our deputy mayor and in particular the mayor for being very fair and thoughtful in the approach that he's taking and working with the police chief as well. Just a few comments on what you outlined there. I'm glad that there was a recognition that there was no paper trail or a clear paper trail of how the decisions were made. I think that's one of those areas we definitely need to improve on, so this way we can tell who's making what decisions and what type of timeline. I also believe that I want to thank that we have Barney Malekian creating this group. I'm glad to see they're involving CPC in that process. My understanding is CPC is supposed to be reviewing the overall process and coming with recommendations. So I hope those two groups are going to be dovetailing with each other and supporting each other. I did not notice you mentioning the OPA auditor, and I wasn't sure.
No, I mentioned.
Okay, so the OPA auditor and the OPA director will be engaged in this process with Bart. Okay, that's great. I appreciate that. The other item regarding the OPA auditor's letter to the police chief, I think it went to, and the information she requested, sort of interesting. I didn't see that actually till today, although I know it came out Monday. I was planning on asking the auditor to provide the council information on Part A, not the officer's identification, but the other areas, going back actually going back further years, because I think that we have a systemic sort of problem here. And I think the best way to approach that is to collect good, hard data on how past decisions have been made and what the process is. So I'll be working with the auditor and our auditor as well as the OPA auditor to make sure that we have information that doesn't necessarily, for at least the council's review, officers' names, but at least to get some data in.
Could I just respond very quickly
Please.
to say that in speaking with our city attorney, Pete Holmes, earlier today, I think we both agreed that while this was not the optimal way in which we wanted to be able to present some of the reform ideas to you, this is actually a very, very wonderful opportunity for us to say, to all of us to come together, to say that for too long there have been systemic issues with this process. And you have Mayor Murray's full commitment that he will exert all of his leadership in order to have a more consistent, fair, transparent process for all involved.
Let me make one point. Did any of my colleagues have any other questions of Deputy Mayor before I continue? And I will keep continuing then. It's not as though we have not been producing data, though. If you look back at Catherine Olson's report as an example, in 2012, 12% of the cases were sustained. 19% there were training referrals. That was up. In 2011, 21% of the cases were training referral. And we're capturing the data in terms of the dispositions that's prepared annually. The last chart did not include 2013, so we still don't have that data. But I'll tell you what's not captured. What's not captured are the number of cases that the chief disagrees with the finding. And I think that's, quite frankly, one of the reasons why we're here. So what I'm asking, I'm looking at Pierce, that when we prepare the auditor report or the director's report, and I'm looking at Anne too as she's taking notes, perhaps we want to capture that as opposed to the great compilations that we do. But clearly, the number of both whether the action of the officer was lawful and proper, which was 21% of the time in 2012, we're capturing that data, but the disagreements, I don't think we're bringing attention to that. Now, having said that, Ms. Polodowski, I'd like you to we blew up this chart for you so the viewing audience could sort of be walked through as well the current process. And somewhere in your explanation, perhaps, maybe you could describe where Chief Bailey made the decisions and Chief Pugil made the decisions 2013 relative to the process.
Sure, absolutely. Thank you so much, Councilmember Harrell, and thanks to the rest of the council members as well. As all of you know, when I was a council member, I actually wrote the original ordinance to create the Office of Professional Accountability back in 1999. So if anybody is sort of the mother of the process, I guess that's me in working through this. And what's been interesting as we've gone through this via this process and thinking about how all of these things work together is I think we've moved from the place that everyone has intended in terms of a swift, fair, accountable, and transparent process with regard to police accountability. If you look at the chart and think about this, it's hard to explain, but really what you've got is 3 or 4 processes that kind of work together in a chain, and not only are there areas where we can improve the individual process, but once you add them together like cars and a train, they're certainly not pulling their weight to be able to achieve the level of accountability that they want. In fact, some of them actually weigh each other down quite considerably, and I think that's part of the breakdown that you saw here with Chief Bailey as he works through these processes. So I'm not going to go through the first part of the process, which is the complaint aspect of the process, but do know, and I think everyone around the table, I know Councilmember Harrell, you've talked about this in terms of your review of this process. I know that Pierce has, I know the CPC has, in talking about how do we make that complaint process easier for everyone here in our community? How do we make it more understandable? How do we make that access just something that needs to change? And that's a whole nother discussion. Then you've got this process that stems from the complaint itself and what happens when you get to investigation all the way through when the chief imposes discipline. So you have a process that you go from complaint to the investigation, see if there is a finding as a result of this. That's part of the OPA director's process and coming through whether or not there is a finding that's sustained. The OPA auditor as well as the OPA director are looking at these on a weekly basis to make sure that the findings are correct. This is one place, I think, as we go through the process that we would recommend from the mayor's office, and I think many other people have said this as well. It's interesting, if you go back and look at the cases that have existed from 2010 through 2012, you've had, about 1,700 cases, I think were in the report from then Auditor Catherine Olson, and you only have sustained findings in 72 of those cases. I think that there is a classification problem there, and we've all discussed this classification problem. In many other departments around the country, when there's a finding that someone has done something where there's some level of discipline or training needed, usually that finding is sustained in some way. So it's then a part of the record of that the officer kind of going forward. What we do is we don't do that in cases of training. We have these things called training referrals that really, they are findings, but they're not really in the way that I think we have intended to make those things happen. So that whole part, in terms of what we're doing with classifications around that, that's a place that's sort of ripe in many ways the heart of the matter here with the chief. After this,
can I ask a question? Just
sure.
And I think one of the challenges we have is a lot of people understand this very well, but let's
Yeah.
assume that they are laypersons that are following it for the first time.
Yeah.
So if there's a training referral in
Yes.
our existing system, that's not necessarily a finding of misconduct or anything on the officer's record, correct?
Correct.
He or she still has pretty much
Correct.
a clean record. And
Right.
what you're suggesting is, in other jurisdictions, if there's a training referral, that still somehow reflects negatively upon the officer's
Right, and I don't
record?
I don't think it's necessarily something that reflects negatively, and I think that is probably something in taking a step back to think about. The system was never designed as a punitive system per se, but obviously you want to get to the greatest levels of misconduct with individuals. The system was designed as an accountability system and an opportunity for officers when they are making mistakes to be trained, to learn from those mistakes, but that it's something that is carried through as well, and that there should be a successful completion of that training when a training referral is asked for, but not just a successful completion of the training, but also demonstrated knowledge that that training has been turned into practice. And I think as we talk about the case with Officer Marion, that was kind of certainly the case here, was this idea not just to send somebody to training, but to send them to roll calls, to review and the review a very clear videotape of their particular behavior, talk about how that's inappropriate, talk about what they've learned, and talk about other officers at all of the roll calls in their precinct to make sure, look, this is not the way we're supposed to behave in the Seattle Police Department. That kind of peer training in education-based discipline and then also values discipline is very effective in making that happen. But there are so many things here that conflate a lot of the issues related to what's appropriate discipline, what's appropriate training, that we need to start to unpack these things. And I don't think that's any different than what many folks around the table have said for a few years now, including yourself.
Councilmember Licata?
Thank you for the explanation. I just want to make one sort of observation, and correct me if I'm wrong, but my understanding is that if the chief decides as a form of discipline to suspend an officer for a day or two, that does not eliminate the police chief's ability to also do training, additional training as well. Is that correct?
Yeah, my understanding is that what's happened in the past, though, is that those things have not always gone together, or they've not always worked in a way that's effective. And again, we've been unpacking it, I guess, for about 3 weeks now. And so there's some issues that are still there in terms of how we would work through the classification process, and then I think the appropriate discipline process with that.
I appreciate that. I guess the point I'm making is that training is good,
right?
And I don't think necessarily we want to say it's either or, either
right. And it could be both, exactly.
Or training. I think we want to see training, and we want to encourage training, but that does not necessarily mean that we would not have a penalty.
Right. And I think what's important, too, is to take some guesswork potentially out of the system and be consistent in these kinds of discipline as well, in terms of when there's a first incident as opposed to a second or a third incident, and how does that ramp up some of these issues, and a consistent matrix to that.
Central Staff Dan Eater had a comment he'd like to make.
Well, I just wanted to underscore a point that you just made, Tina, and maybe draw a difference between what some people might think of as training versus training. I think a common understanding of training might be going to spend some time with a peer or with a supervisor to learn or relearn some aspects of how to do the job well, or to be in a classroom setting of some kind. And the kind of training that you were describing was more training others, going and telling the story of what happened wrong so that the other people can learn what didn't go well and won't make the same mistake. I just wanted to maybe put that on the table.
And in fact, there's both, I think, in that.
And can I just, if I could add, it has become crystal clear to us that in the mayor's attempt to look at best practices across the country, this is one area where the entire OPA process, but especially definitions around discipline and the ways in which ideas around discipline and accountability go hand in hand, where our SPD has been sorely lacking in being up to speed on best practices. And so, Councilmember Licata, I think part of what you're asking is a very, very robust public policy conversation that we ought to have with transparency about where does training fit within a disciplinary framework. You certainly are hearing this mayor, and especially on the advice of his special advisor for public safety, our opinions on the matter. Those opinions and those thoughts are not fitting in well with our current framework, which is also, again, part of the reason why the mayor has asked Chief Bailey, along with Barney, along with law and labor relations, and in consultation with the federal monitor and the DOJ, to go back and review the 6 cases that were overturned under his watch, as well as to put a hold on any future potential settlements.
Yeah. So, Council President Burgess.
So I wanted to first make a comment that
we're having this discussion in the context of the fact that there are dozens and dozens of Seattle police officers out doing their jobs right now. And since we last talked about this episode on Monday, many more of them have successfully completed their shifts and have done their jobs well. And we're very grateful for their work. So thank you, Chief Bailey, to you and your team of, 1,500 people, including the civilian employees of the department. And I also want to say that I'm very grateful for Mayor Murray's very decisive action that you've now relayed to us today. I think that we recognize that some of the transparency that we like to see in this process, and frankly that we thought was built into the process, apparently is not, and I think he's taking steps to correct that, so thank you for that. I did have a question about Mr. Malekian's work. There's kind of two parts to it. One is reviewing the 6 cases, and then there's the broader. What is the purpose of the review of the 6 cases? Is it to identify process issues, or is it to determine whether they should be reversed also, or what's the purpose of that review?
Yeah, it's actually both of those. So it's to really take a look at what happened in the context of those 6 cases from beginning to end, sort of soup to nuts, and try to identify through those 6 cases maybe some other things that we've missed in context of process, but then also to see if the appropriate determinations were made.
Great. Thank you very much.
Councilmember Clark.
So 2 things then. One is for Councilmember Licata's comment about you could do training and discipline. I wouldn't overthink it too much. I think it was just Nick saying you could do training and discipline. You could have them both at the same time. But for the second one then, so if it is taking a look at those 6 cases that where the letters have not gone out yet, where the
Settlements have been signed.
The settlements have been signed. So they'll be reviewed again. And does that mean there might be a different recommendation and then a different action as a result of that?
Potentially.
Okay.
And there's a finite, according to the rules, a finite period. Is there a finite period by which that process is to conclude?
But in the context of those 6 cases, I think our intent is to make that a very swift and finite process. In the context of the entire process there is no end date, which is why we're looking at cases from years and years and years ago. Another fatal flaw.
So, Ms. Palladowski, take us back through where we are. You sort of glossed over the complaint process. I did want to make it clear to those that don't know the process that a complaint can originate from a member of the public, from a police officer himself or herself, from a city council member for that matter. So it's open-ended as to how a complaint is filed. You then have your OPA director's recommended finding and a chain of command meeting, and I think that's where you got some questions.
Absolutely.
So talk about what happens at the chain of command meeting. Is the chief in that meeting, or is it his assistant chiefs, or who's in that meeting, then sort of what, just walks through the chart.
No, that's a chain of the command meeting relative to the officer to talk about potentials for discipline in that context. The OPA director is in those meetings and other folks from the chain of command there. They go through and they would recommend some level of discipline. If that's the case, then there's an opportunity then for that employee to have sort of their final hearing with the chief. And the chief is sort of the final judge at that point. That's what's called the Loudermill hearing. After that Loudermill hearing, which includes the chief, which includes the OPA director, which includes some of the members potentially of that same command staff group, not always, the chief would make his or her final decision in imposing discipline at that point. And that is where the OPA process ends. That's where an OPA case is closed. That's where the complainant is notified. That's where the officer has the discipline on his and her record and has to carry out the implications of that. At that point, though, another process opens, and that's the appeal process or the grievance process of whatever that discipline is. Now, the officer in question or the labor union does not necessarily have to grieve a particular discipline, obviously, but there are some that they do. And if that's the case, then there's a whole different process that comes on the heels of the OPA process, where that appeal can happen through one of 2 ways, either the Public Safety Civil Service Commission or this disciplinary review board. And then prior to this case either being heard through either one of those two venues. The past practice for the last at least 15 years, probably through six chiefs and 4 mayors, has been to take a look at some of these cases and see if they can be settled, as opposed to going to arbitration and the time and expense of arbitration. And usually that's when, I'm assuming that's when, the law department has been asked, hopefully they've been asked before then, about dispensation on these kinds of things,
Can we stop?
as to whether to move forward with that.
Okay, let's stop right there at that process. And on your chart, your, what box, just describe the box you're sort of.
Yeah, I'm sort of in the prior to
employee or
appeal
union can
hearing,
appeal.
the settlement,
Okay.
settlement proposals.
So-
the grievance happens. Yeah, it's interesting because it's as we unpack it, it's sort of more and more things strung together. But-
Okay, so I have a question, and Councilman Licata has a question.
Sure.
So once the chief has imposed discipline and the employee or union can appeal, what is the period of time by which, there's a chair right there, Councilman,
30
we're joined by Councilman.
yeah.
They have how many days to appeal?
30 days to appeal.
30
once
days
the-
to appeal
yes.
after that decision
Yeah.
has been made. Councilmember Licata.
First of all, are there copies of this available for those in the public?
Yes, I put copies on,
So
at the front.
so
Yeah,
everyone has a copy.
yeah.
I really appreciate you pointing out that above the employer union can appeal is where the OPA process ends. And looking at the contract that the city has with the SPOG, the Police Officers Guild, that's where their framework is as well.
Right.
And I think what's happened systematically, and it goes way back, this isn't new to Chief Bailey or even Chief Bujo or whatever. I think what we're uncovering here is a pattern that is not in the spirit of transparency, and I don't think it was a conspiratorial. I think basically it was a fall off from thinking that we went from an OPA, very clear process of the police chief agreeing or disagreeing, and if they disagreed, it had to be a material facts. It was brought back to the OPA director for review, and that isn't included in here, but that is part of it. Once the police chief and the director agree on a sustained finding, if it is sustained, the case is closed. Then what you've shown here is what actually happens, which we did not anticipate, which I don't believe the council members were really aware of, and I'm not even sure if OPA was, quite honestly, is that the settlement process begins. It's interesting because the documents in front of us talk about an appeal. They don't talk about grievance, which is a separate set of rules as I understand it.
Right.
The only time that the union can grieve is when they believe that, and actually the reference is just the transfer, not even suspension or demotion, believes that it's disciplinary in fact, and then they can go through the grievance procedure. So I suspect this has been a system in force for a while, maybe out of culture, maybe out of just people assuming that we just fall into the typical labor sort of relations. But the impact of adopting this bottom settlement procedure has been, and I hate to use this word, but I think it's true, it's really corrupted the intent of OPA to be transparent. And what we don't know is how many decisions have been basically negotiated away without the knowledge of either OPA or the council.
And Councilmember Licata, before Tina responds to you, I just also want to make it clear. I know it's apparent to all of the city council members, but for members of the general public and for the audience, I also want to be very clear in providing the answers via explanation. This is not, please do not take this as a defense on the part of this mayor or this interim chief of the current system. We are absolutely vested and interested, along with everyone else here and the OPA auditor and the OPA monitor, to reform this system.
I think that's well understood. Thank you.
Thank you.
No, I think that what's right and what happens is something that's really quite pivotal here, which is when the case closes, when the OPA system closes, essentially what you've had is an issue between a complainant and an officer that's gone through a process that is fairly transparent. The transparency can be improved. Some aspects of the system can certainly be improved from that standpoint. But then when you get through to the grievance process, it really becomes more of a collective bargaining issue, and it becomes a process then between the guild and the city. It's no longer a process between the complainant and the officer. And I think that that's where your point is well taken, is that I don't think anyone ever meant to push those two processes together and seemingly think that they were one. And there's a lot of questions I think that we can ask around how that happened, and that's at the back end of this. I think there's a lot of questions we can also ask at the front end in terms of the complaints themselves and some of the other aspects of the classification. So here's where you're starting to see where things are breaking down, either intentionally or unintentionally, specifically when they come together around this point as well.
As was pointed out earlier by the chair, and Councilmember Burgess earlier, there's no time limit. That was one of the major problems. After the case was closed, the settlement process had no time limit. It stretched on for years. We're going back to cases that are literally 3 or 4 years old, and that obviously is a fatal flaw as well.
Yeah, and I actually think you probably had situations where you're dealing with cases that are more than 3 or 4 years, but even 6, 7, 8 years old. And that's something that's different too. One great example in terms of this particular process in the state of California is that you have a year to deal with it in that state. And sort of I'm taking a look at the different options we might have around that. So as we start to have these discussions, and Barney's working through this group, we have a good sense of what we may or may want to do moving forward on this.
Maybe I can put some context around it, though. As a police officer is a city employee, and by virtue of that status has employment rights, grievance rights, and appeal rights. Now, it can take a couple of years for that to be resolved, but regular city employees that are not police officers, is that typical? And I'll turn to Susan a little bit, and it might be a tough question, or David. Is that typical in transportation or city light or any of the other departments?
For our civilian contracts, we have grievance processes and we get demands for arbitration. They too do not have a drop dead date or a time frame for which those need to be either acted on or not. And it's a genuine issue. I can understand it raised here and there. So we have outstanding demands for arbitration with our civilians that are probably years old as well.
Several years. Okay. So this process of the employee discipline piece that can last for years is consistent with our overall scheme, it seems to me, from what I'm hearing.
Right.
Ms. Paladowski, I had some further questions from other people at the table. Were you finished going through the chart, or do you want to keep us?
I think pretty much so. I think we could probably talk this process to death, and I think
we will.
I think we probably will. And what I'd rather do is come back to the council in a little bit and talk through what the new process might look like at some point. So let's move on to questions.
So, Council Member Clark.
So I appreciate this walkthrough of the chart, and I think you use some terminology that I think has become more important to us in the past week, which is after the blue box with the if chief imposes discipline, I think you described it as the OPA case is closed.
Yes.
Which is a very specific way of describing that. It is not, what we've learned now is not that the whole deal is closed, it's that the OPA case is closed. And I think we all have realized that there's an opportunity to appeal these. I don't think that's a surprise to anybody. I think where I am learning a great deal is that, for instance, as council president last year, I received a handful of these. Determination has been changed. Here's my notification that I'm differing with the recommendation of the OPA. My assumption was always that those letters were happening in the first half up here before you have the OPA case closed, but that it is part of closing, bringing everything to closure. I think it's these two boxes that are the prior to appeal hearing settlement proposal and the settlement agreement reached possibility, where it is, and I think we've all noted this. We've worked really hard. You started, having the city work really hard on figuring out how to have an accountability system, an OPA system that matches our rhetoric about wanting transparency and accountability. And in many ways, we're light years ahead of where we were a long time ago. This is causing me and others, and you all, clearly in the past couple of weeks, a lot of issues, because it is sort of a second bite at the apple that none of us had really anticipated, and it's still very unclear sort of how you then get the public back into understanding what happened with a discipline decision that they thought had already been happening. They read about it in the paper, or they saw it online, or they saw it in the report. And I would not want to deny anybody their appeal possibility, but my assumption at that point is we've made our decision, and it's going to an arbitrator or to the Public Safety Civil Service Commission to deal with at that point. And if a decision is made, it needs to also be public, and there needs to be some way to close that loop with both the complainant and with the public about what happened.
So that's one of the points I want to raise. Just one moment, Councilmember Godden, you have the mic next, is the document I passed out, and let me use this as an entry point. The document, when the chief does reverse the finding of the OPA director, he's required or she's required to notify the mayor and the council. And again, this has been done several times last year and this year. What I'm asking Central Staff to do, and apparently with Barney Malikiam and the CPC and others, is to see if that section that Councilmember Clark is raising needs to be expanded, whether the auditor, the director, the CPC, the public safety chair, and others, and the complainants and the public should also be on notice when that occurs. Now, one could argue that that's overkill, that this is an administrative notion. I don't think it's appropriate for a council member to substitute their judgment for the chief's judgment. But I think it is appropriate for the elected leaders to make sure that that process is transparent and that we're able to track that through the auditor's report or the director's report. And I don't think we've been doing that. So we'll come back to that. That's a conversation we'll have as we revamp the system. I had a Councilmember Godden, you had a question. I think, Pierce, did you have a comment you wanted to make?
I just wanted, if I could, Council Chair Harold, just to follow up on your last point. I think that language that requires the letter from the chief was mostly understood by my predecessors and by me as I came in here to apply to the part of this chart right before when the chief imposes discipline. And I don't believe the practitioners in the system anticipated the reversal of sustained findings later on during the appeals process. So one thing as you're thinking about this and talking about it is perhaps there may be a need for more clarity in the language of that ordinance to make it very clear that a reversal later on also requires some public notification.
Very good. Councilmember Godden.
Well, that was sort of one of my questions, and what I really want to know is, do we have a separate chart for the complainant or the person who is has brought the complaint on the behalf of someone?
It's an interesting question because I know that that's something that Director Murphy and I, we've talked about a bit, and the complaint process itself can be interesting and convoluted in its own right. So I think you're getting to the heart of the matter that even in the way that we talk about this process and for that individual who makes the complaint, the language that we use, the process that we use, the notifications that we use, what that means in terms of somebody getting a sense of resolution and satisfaction is lacking in the current system. So I think that that's also a part of it here. And as we've talked about the complaint process and what happens, and even the length of that complaint, and I'll leave it to Director Murphy to talk about some of this, but many times you have a situation where someone makes a complaint, it might be 6 months, 8 months before they hear back about the disposition of their complaint. And what they get is a letter that says it was sustained. I don't know about you, but if I made a complaint about X and I got a letter 8 months later that just said it was sustained and I didn't quite know what that meant or what the implications were, first of all, I'd be mad because it took you 8 months to get back to me. And second of all, I'd be mad because I have no idea what this means. And do I have a sense of closure around this? That never happens. So I think that also hurts the credibility of the system tremendously because I don't think we're doing as much of a service as we can to the complainant from that standpoint. I'm not so clear as well that it's the same for the officer either, and that needs to be a part of it, that everyone has a sense of, what is the resolution here, and then how do you move on from that point.
If I could move us on a little bit, and one of the recommendations from the auditor in her last report, I thought was a great recommendation, was to, in many situations, a simple call back, an apology. There could be an informal means to put closure to it quickly without triggering this very elaborate process in some of the other situations. And so I think we want to explore that. Right. Did you want to see? I had a
yes. One comment too is that I think some of this too. Originally, the OPA process. The volume of things that are coming through the OPA process. Some of these things really are issues that need to get referred to a supervisor to deal with. But there's really not a great way for that supervisor then, in the context of that process, to have a discussion with the complainant or for the officer involved to have a discussion or to figure
Right.
out a great way for somebody to understand what's happening with that. So I think that that's exactly
Sure.
what you're talking about.
So as we wind down, I want to bring in both the police department, the chief, and the law department into the mix a little bit. And I have a question in the Marion situation. When a chief makes a decision and you're seeking input from a lot of folks, and we understand, and I really appreciate the mayor's candor on this, that there was somewhat of a breakdown in communication, perhaps. But the chief seems to seek input from the law department, and you have identified the lawyer here as a lawyer. Can you describe a little bit about the process that you seek? What's the interplay between who you define as the police lawyer and the law department? How does that look like when you're looking at these decisions? And then I guess because you're the interim and you've only been doing it for a few months, maybe those more familiar with the process will describe how it's supposed to work a little bit. So,
Rainey is the in-house attorney, and in this particular case, we went over a series of cases on the matrix that we had, trying to determine the weight and the weakness of each one of them to see if we wanted to go forward with them or whether we wanted to settle them. In this particular case, and looking at it, getting the background from the in-house attorney, I made the decision that if we were not going to terminate this person, then it was my goal to try and make that person a better person to reflect the values of the Seattle Police Department, which would have been training, not knowing that that would then trigger a sustained finding. So that was the process.
So in most situations, is it, and this is a question for the table, and I guess maybe we'll examine this. Does the chief seek advice from the in-house lawyer, or because the other 6 cases he sought advice from the law department? And is that an issue as to where he seeks legal advice as he makes his decisions moving forward?
Sure. As is typical, I think in all major departments, there's a legal advisor within the department for the chief. But I think in this case, you've moved beyond the purview of what a chief would do in their normal course of business and talking to their own in-house legal counsel. And this is certainly a matter where you'd want to get counsel from the law department to do that. You've moved out of this whole complainant officer realm into something that really affects the labor union and the city attorney is the city's attorney in that case.
Please.
So, if I could, the process that was in place, still is in place when I arrived at the department with respect to these kinds of decisions, when I came to the department.
Which was when, by the way?
2008.
Thank you.
2008, January of 2008. When a case would get a challenge, then there were a lot of discussions about what could or should happen. As I understood it, there wasn't a lot of back and forth with the city attorney's office about that. That was decided in the department. One of the things that I did when I got here is I worked very closely with the city law department and the employment section folks. I did not want to work in a silo by myself, and so I bounced a lot of things off the law department. And the decisions by the chief, generally, there were very few that the law department would not have been aware of. But in this situation, it was a timing issue where all of these are on the table. They came up. The law department got a chance to review them, and the 7th case, the Marion case, that one in essence ended up being tacked on at the end. But generally speaking, for the department, as long as I've been here, I've worked very closely with city law in making sure that we're all on the same page about the cases and what should be going on with them.
And who do you report to?
I report to the chief of police.
So you have the difficult job of giving legal advice to your boss.
That's correct.
And I just wonder if that warrants some structural scrutiny as we move forward. And maybe it works, or maybe it works well. But I think that could be one issue because the interplay between your position And by the way, I've heard great things about you, so this certainly is not an attack on you by any stretch of the imagination. The interplay between your position and the law department is probably an area of concern that Mr. Malikian would look at. Councilmember Rasmussen, you had a comment or a
I
question?
just wanted to make sure I understood what you said. So when the chief, in your experience since 2008, when there's been a disciplinary decision made, the case was closed, and then the chief was thinking of reopening it, you would always run it by the city attorney first before the chief would make a decision?
So the word you use, reopening, it's a term, I suppose, that you could characterize it that way, but the way that I viewed it, and I think the way that everyone else understood it, we had a litigation or a legal challenge matter. So it was opened from the perspective of, if we don't do anything, we're going to be sitting in front of an arbitrator or a disciplinary review board panel and have a third party decide and tell us what to do. So, as with most litigation matters, you try to settle as many as you could. That was the approach. Yes, I talked to, and I can't say that I talked with the law department about every single one of them, but like I said, I did not appreciate working in a silo by myself because, you know, one can assume how brilliant you are and read your own stuff and think you're really great, but I always like to bounce things off other folks so that I would know.
Okay, so changing the term, so when a case was on an appeal and you were thinking, or the chief was thinking of settling it, then generally you would run it by the city attorney's office before the chief made that decision, this chief or others. About how many of those have occurred since 2008? Any guess?
Settlement?
Yes, before the appeal was finally heard by the Disciplinary Review Board of the Public Safety Civil Service Commission. Any estimate, over the last several years?
I think that's part of the review we'll be undertaking.
Okay,
Just to get really clear
I
on
think
that.
I wanted, Deputy Mayor, did you want to make a comment there?
Well, only to the extent that I think, back to Councilmember Licata's point about consistency and documentation. I think those are also things that, again, both Mayor Murray and Chief Bailey have inherited, and given the volume of complaints that SPD in particular has been handling through the OPA process, I mean, a lot of things kind of came together where there were checks and balances that didn't occur with the city law department. In the Marion case, it was very easy for Mayor Murray and Chief Bailey to say, you know what, we didn't have that checks and balances in that one case, and therefore it was an easy decision to say, no, we're going to go back and reinstate. In the case of these other 6, it took us a couple of days to fully understand at what point did Chief Bailey's predecessor give the green light. And while it was Chief Bailey's understanding that that had occurred, the lack of documentation to that effect gave us pause and worry. And so what you are hearing from us is a process that we have been unearthing for ourselves in public daylight. Not always the best way, but it is what it is. And in order to be able to best understand where should those checks and balances are within our existing system, what control do we have to ensure that kind of accountability in the broader system, and where it lacks, we want to, again, place a hold and move forward.
Okay. I want to get to public comment pretty quickly here. I have a direct question for Chief Bailey, and then Councilman Licata has a question. Can you just describe, I was asked this question, and I want to make sure I answered it correctly. Is really why I'm asking you this. So on Officer Marion case, can you describe exactly what the status is now? He's one-day suspension, and is there still this training of other people that will take place? Can you clarify that?
His status is the finding has been replaced as sustained with training.
So the sustained finding is in place, and he will do the training that was preferred to begin with.
He's completed that 5
And he's
days.
already completed the training. Very good. Thank you. Councilmember Licata.
Right. Well, again, I want to thank the mayor for taking the initiative on this and recognizing the whole scope of the problems we're facing and going forward on it, and the cooperation of the chief giving the mayor as well. But the issue that Councilman Rasmussen raises is, as you pointed out, Deputy Mayor, what we need to get at. We right now don't know how many sustained findings by the chief, whoever was the chief at the time, have ultimately been, for lack of a better word, I use a layman term, reversed in settlement, so that there was no longer a penalty, and that we don't know whether it's a few, we don't know if it's half of them, we don't know if it's the majority of them. We have no way of, at this point at least, until we go further collecting data, what the scope of this trend has been.
And then what I would add to that would be helpful to know is, was the the complaining party notified of the results? Maybe you've asked that, but we need to know, because people want closure to these cases too. If they've complained, they want to know how it's been disposed.
Sure. I think in the case of the Marion case that the complainant knows dispensation in this
well, I'm
particular
thinking,
case.
we're
Yeah.
going back.
Yeah.
And to that point,
Yeah.
again, this is where we are fully embracing and welcoming, I think, the foresight of the OPA auditor in her letter to Interim Chief Bailey this past Monday, asking precisely for some of that kind of data. And again, we welcome the opportunity, like you, to better understand systematically what has been occurring.
Because
So-
one of the common
I'm going to try to move on.
things that I've,
Councilmember
well, I'm
Rasmussen,
sorry,
please.
I just got here.
Well,
So the common
we've
things
been
that
here
I've
for a
heard
while, so.
is that people make a complaint and nothing ever happens. So that's what they need to know. So what had happened?
Right. I just want to.
And that really builds confidence towards the police department. Thank you.
I
Thank
just
you,
want to
Chair.
very quickly, I know that you want to move on, Councilmember, put some things in context, but.
Well, we're repeating ourselves a lot,
Okay.
quite frankly, and we're in
Yeah.
what I call violent agreement
Yeah.
on what we're trying to do.
Yeah.
So I'm just
But I
trying to
think
move us on.
I have some numbers for you just to
Okay.
put them in context, and because I think this speaks to what Councilmember Licata had just been talking about, which is, if you go back 2010 through 2012, so that time frame, because I don't have all of Pierce's data yet for 2013, but we had approximately 1,700 complaints against officers in the Seattle Police Department. About 600 of those, or a third of those, were ones that were referred for investigation. And then of that, we have 72 sustained complaints. So those 72 sustained complaints, potentially with others previous, because we have this never-ending process, are kind of the universe that we're talking about here in making this happen. And I do feel sort of duty-bound to say, if you look at that universe in terms of complaints and complaints against officers, that within that context of that time frame, 85% of the officers in the Seattle Police Department never received one complaint through that. Of the rest of the complaints that we're talking about in terms of officers, what we're looking at is one, perhaps, at most. It's that universe of 1%. I actually think it's 1.3 or 1.4%, where you're looking at 3 complaints or something within that realm. So I think it's important, too, in the context of accountability, that the accountability system be one that properly adjudicates all of that in the context of fairness to both the officer and the complainant as well.
Okay, thank you. I do want to apologize for being a little pushy on prodding my agenda, but you guys didn't just meet me, so it's okay. One comment, a closing comment, if I may, on the work that Barney Malikian is going to do, and I'm excited to see it. I want to read a portion of the auditor's report back in 2012, where she says, because the department has so many reforms already underway, based on existing auditor recommendations, requirements stemming from the settlement agreement with the Department of Justice, overseen by the federal court's appointed monitor, also the related memorandum of understanding, and the work of the Community Police Commission. My intention is to keep additional recommendations to a minimum to help enable the most expeditious implementation of those reforms underway. Now, I make that comment to say that this document here is a document that our committee put in place. It has 141 recommendations of reform identified by central staff dealing with many vested stakeholders in this process. And then we were asked by members such as the ACLU to hold off on some of this because of the work the CPC is doing and the reform group is doing. I say all that to say that we're adding another layer to this now, and we have recommendations coming out of our ears on this stuff. And so what I'm hoping that we can achieve through Barney's work and the executive's work is to sort of quantify and harness all the reform work into a very clear path of reform, because my concern is we got a lot of folks that want to take ownership of reform. And so that's why I welcome his work to scope it a little bit, because we have a lot of chefs in the kitchen. And having said that, that might be a good way to open up for public comment. And I did want to say a few things about, we have 9 speakers. We're going to start off with Rich O'Neill, who I did want to say today is actually his last day as SPOG president, and I think we can all agree he's served his members very well for the last several years, and he's passing the baton to Ron Smith. We have 9 speakers. We're going to start off with Rich O'Neill, and our last speaker of the 9th is Dominic Holden. How's that for poetic justice in the order of speakers? And we ask that you confine all comments to 2 minutes. And Rich O'Neill, again, on behalf of the council, thank you for your great years of service as SPOG president. And the microphone is yours. And after you, we'll hear from Ms. Queen Pearl.
Thank you. I'm speaking today as president of the Seattle Police Officers Guild on this, my last day in this assignment after 8 years. There's been so much misinformation in the media the last few days, and I hope to make the record clear. When an officer faces discipline, they go before the chief of police in what's called a Loudermill hearing. Most of the time, the officer accepts the finding, and sometimes they only disagree with the amount of discipline proposed. Would you take 2 days instead of 5? Would you take a reprimand instead of a day off? That kind of thing. The chief of police alone has the authority to issue discipline and may change a sustained OPA finding after listening to the officer. Let's keep in mind that just because the OPA recommends a particular finding, that decision is not infallible. At times, mistakes are made in the OPA investigation or even in the analysis of that investigation. Following the hearing before the chief, the officer has the right to appeal the decision before either the Public Safety Commission or a discipline review board with a civilian arbitrator. Again, most of the time, there is no appeal. But on the few occasions where there is an appeal, the hearing is usually set far in advance. These hearings are time-consuming and costly for the City of Seattle and the Guild. Every single chief of police in my 34 years on SPD has settled grievances and discipline appeals prior to an actual arbitration hearing. This is done to save time and resources. The reason for the backlog of appeals and grievances, some dating back to 2011, was because, especially in election year, no one wanted to make a decision. Chief Harry Bailey was brought into the Seattle Police Department to make decisions. He has made more decisions and created more positive change in the last 2 months than anyone has done in the last few years. By settling cases, Chief Bailey has done nothing different than any of the other chiefs before him. Chief Bailey has more police experience than anyone in this room, and I find it appalling and extremely disrespectful that the first African-American chief in the history of this city has to have press conferences and be brought before the city council to justify making a decision in a minor administrative case involving a violation of courtesy. And while we're talking about a violation of courtesy, why don't we explore the fact that in 2008, the city had a blue ribbon panel chaired by Judge Terry Carroll with distinguished members including Hubert Locke and Jenny Durkin. The citizens recommended that OPA should focus on serious acts of misconduct, and all others should go to mediation or the officer's chain of command for action. This has never been implemented. The case in question this past week should have been sent to mediation so the officer and the complainant could sit down like adults and explain their positions instead of grandstanding in the media. I fear that the events of the last few days will hamper our search for a permanent chief of police. Who in their right mind will want to apply for the job if they have to check with 8 different people and check the political winds before making a decision on an administrative issue? The events of the last few days are nothing but a power grab by some who want to wrestle authority away from the chief of police. They are using these minor administrative case decisions to further that agenda. If they want to run the police department, let them apply for the job. Give the chief of police, especially Chief Harry Bailey, the respect and confidence that he has earned to make decisions and run the police department. Thank you.
Thank you, Mr. O'Neill. Next, we'll hear from Queen Pearl, followed by Sam Bellamille.
Yes, giving honor to God, first of all, who's the head of my life, and to honor Rosa Parks during Black History Month. But I'm reminded of swelling speeches and enticing words of man's wisdom that doesn't amount to a hill of beans, as my mom would say. And we're in crisis mode. And when we're in crisis mode, we deal with the crisis at hand. And I grieve for the people that you so swellingly give so much glory and honor to. But we got dead folk probably crying from the grave. They never saw righteousness occur for them or their family. And then stuff is appalling and shocking and dismaying to me to even have to come down here and to hear people say that people are doing such a good job. I'm from the show me state. You show me how good you are, huh? Because I'm not seeing it. And I mean, Stevie Wonder is blind, huh? And I'm just really kind of I'm here, but I'm not here, because this is not the kind of realm that I like to deal with in the first place. Because I've gone to particular meetings and stuff like that, and they have just abused black people over and over again repeatedly, irrespective of what they say. Like we don't have no rights on the face of this earth to do nothing and say nothing and have nothing either. And so it's just despicable to have to come down here and hear that someone have violated, I'll just speak. The latest issue is Dominic Holden, and he was just standing there. I guess he didn't have no right to say nothing. Then you say, oh, but yeah, he was wrong. But no, he's not wrong. Yeah, but he was wrong. Oh, no, but that sounds like howdy doody time to me. So it just seems just like it's commercial and it's comical and it's full of dead men's bones.
Thank you, Ms. Pearl. Sam Bellamille, followed by Mr. Alex Zimmerman.
Yeah, my name is Sam Bellamio. I'm here with Stand Up America. I'm the vice president of the organization, actually. And you've seen us come down here many times. I'll just put my phone down. So it's kind of like when we go to Iraq, a bunch of people die. It's soldiers' fault. It wasn't Congress. It wasn't the president. It was damn soldiers. You know, we talk about all the policemen, those horrible policemen. But you ever think about the situation that they're put in? About the fact that the management is the actual problem that we have here in Seattle? It's the police chief, it's the mayor, it's the council. But yet, in 15 years, in 5 years, no, we started it yesterday. Something's going to change. Nothing has changed because we sit at this table at this awesome time at 2 p.m. 2 p.m. You canceled 2 other meetings today to hold this meeting at 2 p.m. This is a special meeting. Not sure what's so special about it. You hold 20 minutes. You put 20 minutes exactly on here. 20 minutes, how long you were going to hold public comment today. What's so special about that 20 minutes? Oh, they have the Community Police Commission. What's so special about that? 9 a.m. 9 a.m. is when that meeting is held. Queen Pearl, Michael Fuller, I think are mainly the only 2 citizens that show up besides your appointed people. Those people were your picks. You hand-selected them. The citizens aren't involved in this process. The whole thing's broken because you're in charge of it, because you're doing nothing to change it, because you're holding it at 2 p.m. Something needs to change. Not tomorrow, not in 5 years, not we just started it. It needed to be done yesterday. You need to start doing something and standing up and doing things right. Bruce Harold likes to tell media that Stand Up America lies. Am I lying that 2 p.m. is an outrageous time to hold a meeting? You think it's just normal that no citizen can come because they're at work? Okay, I guess I lied. I guess your salary is $120,000 each. Isn't it excessive? The mayor, $180,000, which is more than the governor, who only makes $160,000. That's not excessive. But yet we have people dying in the streets because there's no housing for them, no food, no shelter. Oh, you're right. It's not excessive. You deserve more pay. We should give you at least $1 million each. What am I lying about, Bruce? You know, in the past few years that we've been coming here, you've had more citizen participation because of us.
Time's up there, my friend.
I know, but you let that gentleman speak.
He's taking your time, my man.
But you let that gentleman speak earlier for 4 minutes. Just let me finish by saying.
Go ahead, please conclude.
Thank you.
I can hardly wait.
Yeah, I know. You're just anxious to get me away from the podium.
I am.
But yes, I would like for you to do something and change something. It's a joke, and it's scary to me because Ukraine is only an example. The U.S. has guns. There's going to be people in the street rioting because of your inability to change.
Mr. Zimmerman,
we aren't any different. You're oppressing us.
Start the clock for Mr. Zimmerman, please.
I like you. You are a freaking clown. I talk about this for many years. For 25, I'm sorry.
And I'm not going to tolerate this name calling.
Man, 25 years.
Sorry, he's talking about the government.
I spoke right now, not to you. I spoke to everybody who listened to me. People,
yeah, but I don't
this
like the name calling.
Will be doing again and again for 25 years what is will be doing for another 25 years. Soldier guilty. Poor soldier, always guilty. 1 day suspension. How about 7,000 people who go in jail every time? Almost 100% prosecuted by policemen, prosecutor, and judges. 100% more. Oh, yeah, these people in Iraq kill children. Who's this freaking idiot who don't understand what is happening? Are you freaking all idiot? No. You crooks by 100%. A small one-day suspension, wow, and look what has happened. A big typhoon come, a storm, a tsunami come. Is this tsunami talk about how big we are? You are freaking all crooks. So I speak right now to everybody who listen to me. Before we not change this crook, like happened in German Nazi in 45 in Nuremberg process, nothing will be changed. This crook doing again and again and again for 25 years, what is I know. And I'm fighting with this crook like this crook for all my life. It's very simple. We need stopping this. We need talking about big problem what is we have. One-day suspension is not a problem. It's normal business. It's probably sergeant business, maybe captain. It's very simple. But you freaking idiot, it's a problem. If we elect you again and again and again, and we elect new mayor who absolutely freaking idiot. And everybody knows this. And we elect again and again and again, same freaking idiot. And nothing fucking changed. For 25 years we've fallen and fallen and fallen. Because fish always stinking from head.
Time's
Before
up.
we not clean this chamber, nothing will be changed.
Thank
this
you,
is exactly
Mr.
what it's
Zimmerman.
supposed to be. Stand up, America, or live free or die.
Thank you, Mr. Zimmerman. Thank you very much.
Yes,
Ms.
sir.
Diane Earl, followed by Catherine Moore. Do we have Diane Earl here? So we'll move past if we don't have Ms. Earl. And Catherine Moore, followed by Jennifer Shaw.
Good afternoon. I'm Catherine Moore, the co-chair of the Seattle Human Rights Commission, and I want to thank everyone for being here and giving us the opportunity to address you. It was very helpful to have this chart, and I think our position is that we agree with the comments of Councilmember Licata, which is that the settlement agreement process has basically corrupted the OPA process. And what I've heard here today is a lot of very smart people who have a lot of goodwill who want to make this work. But what I haven't heard here is a fundamental commitment to addressing the fundamental flaw that is this process. And the question that has to be addressed by the council and by the mayor's office is who is going to control discipline of the police department in the city of Seattle? Is it going to be the police department, or is it going to be the citizens whom the police department serve? You have to make a political decision. It has been the commission's position since 2012 that there needs to be an independent civilian review board that has the authority to set aside the final disciplinary decisions or settlement agreements made by the police chief. Until such process is put in place, all of these good faith tweaks are not going to change the fundamental problem that this is a political process that can be viewed as a political process, and you are not going to have buy-in by the public. I think a good example to look at is the Judicial Commission. Judges have as much desire to preserve their prerogative as the police department, and they went kicking and screaming. But eventually a judicial commission was established, which is an independent review body that reviews complaints against judges, the people who also control the ultimate issue of life, death, and liberty in our society, and they are able to impose independent sanctions that hold. That is the commission's position, that there needs to be a similar body, and that these people need to take a political position and not be worried about what the ramifications are. And I'm just going to say one last thing.
Please make it about.
As political leaders, you have to decide what battles are worth putting your elected office on the line for. Not all battles are worth that. This battle is worth that. And I call you, this is a call to action to make that really difficult decision. Are you going to take on the police union and make the right choice, or are you going to work around the edges, and we'll be back here in another 2 years with the same problems? Thank you.
Thank you, Ms. Moore. Jennifer Shaw, followed by Reverend Walden.
Jennifer had to leave.
Jennifer had to leave, so Reverend Walden, followed by Dominic Holden. Oh, Diane Earl, why don't you go ahead and speak? Well, we had called you, but I didn't see you come to.
Well, I was a little upset.
Oh, no problem. So please come forward to the mic, please.
what it is,
I need you to come to the mic right in front of, there you go. Very good.
I have, okay. What it is I'm here in support of Dominic Holden, but I like the interim police chief. He took time out to sit down. He's the only last of the three that we've had in office over across the street that allowed me the time to hear my side of the story and told me it will never happen again. But my support for Dominic Holden is because my same story, like Dominic's, started in 2007 when Seattle Housing Authority's police officer had me in the office cussing me up one side and down the other. He told me if I ever called 911, since I lived in their building, he would be the one to respond. I had to step over Seattle City Council. I had to step over even the state and go to DC and talk to one of my representatives. And he told me, if that cop ever bothers you again, you call me. Didn't work. That guy, the officer, I'm not going to say his name, from 2007 to 2011 harassed me. He allowed a former SHA employee to threaten me with death. He allowed a former SHA employee to take a butcher knife after me. Now, I had to put up with that for all these years. And it came to the point where I finally filed in 2011 another OPA complaint case with this same officer with his partner that recommended to Seattle Housing Authority that they throw me out in the street and filed charges against me for across the street for calling 911 to report all the harassment I had been taking when I had an anti-harassment order against this man that made those threats against my life. Now, in this, it's all...
I need you to start wrapping up, Ms. Earl, please.
Okay, I will. It's all unfair, but do you realize that I had documented proof of everything, the anti-harassment order, but my second OPA case was not sustained. It was not this new OPA director. I appealed it. It took her 2 days to say, no, I'm going to uphold it. There's people like me. There's people like Dominic, and like the former lady just said, it just didn't happen yesterday.
Thank you, Ms. Earl.
Mine was 2007.
Thank you for your testimony.
Thank
Reverend, thank you. Reverend Walden, followed by Dominic Holden.
Thank you. My name is Reverend Walden, and I'd just like to spend 1 minute of my time to tell this lady that I'm sorry that she had that experience. I'm sorry. I really am.
We're all sorry.
Yeah. I felt so moved that I needed to say that because her humanity spoke to me. And I also like to say that it's been many, many reports from the auditor that has gone to the to the police department, to the city council. And over the years, the chair of the public safety has never taken that to the extent that is happening now. So all I'm saying is that had we been looking at some of those recommendations, not only by Judge Levinson, but by all the other people who's been in there, I think we could have avoided having the Department of Justice come into Seattle, because there's been recommendations, recommendations, and recommendations. And I want to say that Mothers for Police Accountability really respects and support Chief Bailey as he moves to reform. And it was said very rightly so by Rich O'Neill, is that he has more police experience than anybody else around the table. And I really want to concur with that statement. But we're here because it was an incident. It's been a lot of incidents. And I just want to say that going forward, we need to have a way to be able to get these complaints out, to get them settled at a more rapid time. And I think that the police chief should maintain some measures of discretion. I mean, some at some point. Otherwise, you don't need a police chief. Maybe, I mean, and maybe that's the way we're going. Maybe Seattle will be the first city to be able to handle all of its problems and not have a police chief. I mean, it's a model in a lot of ways. So maybe that's the way that we're going. But anyway, I thank you for your time. And again, I just have to say, for us as a group in the community, we support Chief Bailey, support the reforms. I mean, he's done more reform in 6 weeks than all the predecessors. And so I don't think that this event should be like a mark on his ability for leadership. I really don't think so. So anyway, thank you so much. And again, I want to just tell this lady that maybe people up there can't say that they're sorry, but I can tell her that I'm sorry that for her experience that has impacted her life so much.
Thank you, Reverend Walden. Our last public speaker will be Dominic Holden.
Hello. I'd like to thank the mayor's staff for coming today. I'd like to thank the chief. I'd like to thank the chair of the committee, Bruce Harrell, for opening this up so it's a public process. And I want to thank the rest of the council as well. In particular, I listened to the briefing on Monday in which Councilmember Rasmussen had obviously taken a lot of time to become very informed on this, even though he's never chaired the Public Safety Committee. So I want to say thank you. I'm here as the complainant. And I'm also a reporter, which is an unusual position. And I know that the chief has commented that that is odd. I didn't want this incident to happen. And I wrote about it because I wanted it to be sort of a test of the public complaint system in a very public way. And I was hoping to make it open and make it transparent. In doing that, by writing about this and having it in the media, I think that the public has been able to see the problems with the complaint process. The council has been able to see those problems. And so we are all now working to improve the accountability system. So I think that is a good thing, and I'm going to continue to act in both capacities. The chief was a little hostile to some of my questions when I asked them at a press conference on Monday, so I'm hoping the council can do a better job at getting some of this information to the public. So I have questions both from the position as a complainant and as a journalist. First with the complainant. I'm probably going to run over time, and I apologize. My complainant questions are less significant in the context of the broader question of police reform. But why was my case singled out by this new administration with no consultation with legal? What was the impetus for its special treatment? When was this decision actually made by the chief? We were told today, and at other times I believe, that the training happened weeks ago. That suggests that the decision was made long before a settlement was ever turned into the OPA director, Pierce Murphy, which seems that this decision happened a long time before there was any real documentation about it. That seems troublesome, and it seems secretive. Can we see this settlement? We've heard from the police chief, we've heard from the mayor's office that there was simply a misunderstanding and confusion. Being able to unseal that settlement agreement, see what the chief was signing off on, should be able to settle those questions. And we should be able to see that publicly. I'm curious if this case was treated differently because it was public. There are 6 other cases that were private, and their disposition right now is different. We shouldn't be treating public cases differently than private cases. I'm glad that this is a public case, but people who do not want to have their cases be public should get the same outcomes as people who want them to be out in the open air. It's not fair to complainants, and it's also not fair to cops. It's not fair to Officer Marion if his case is being treated differently than other police officers.
Dominic, can you at least make an attempt to...
I will wrap up. I'm very close.
Thank you.
In the general public interest, as a journalist, I'm curious how many of these cases have gone through this 3rd track? Is this unprecedented? And what is the statute of limitations for reopening these? Where does the authority derive? And should the chief have this authority, or should there actually be a requirement that this be in arbitration or be before the Civil Service Commission before we can have a settlement? How can you have a settlement if there's not actually an appeal underway? And finally, I would ask if the council can make publicly available the vast majority of its findings. I know that there's some things that need to be redacted, but we can restore public trust that this is a transparent system and that people get a fair shake if the council goes out of their way to post these documents online. Thank you very much.
Thank you for your questions. We will hopefully give you answers to your questions. Good questions. Before we adjourn, I was going to ask Faye Lopez on behalf of the Community Police Commission, or neglected to ask any ideas you had on reform, but I'm going to ask that you make it brief so we can adjourn. Ms. Lopez, please.
Hi, I do appreciate this opportunity to talk about the CPC's role, the Community Police Commission's role, and ongoing work on not just the OPA, but on the accountability process as a whole. Per the MOU, the CPC is charged with developing recommendations to the OPA structure, but we also understand that we need to make recommendations to the whole accountability system. CPC and the CPC Accountability Work Group include a group of independent actors that include community members, the civilian auditor and director, and representatives from the Monitor, the Department of Justice, unions, and the SPD officers. The CPC intends to deliver a full package of recommendations regarding the accountability process and system within 6 weeks. And in light of current issues, the CPC is willing to expedite recommendations related to the post-determinations to discipline. The CPC welcomes Mr. Malekian to join us in this important work. So thank you for that.
Thank you, Ms. Lopez. I want to thank all of you for being here.
Mr. Harrell, would you please let me speak? Your
we'll meet with you,
assistant
Paula,
told me.
after. We'll meet with you after. I'll stick around. I'm sorry. I'll meet with you off. I want to adjourn these good people. I want to thank all of you for being here. We have a lot of work to do. The work is just beginning. And with that, we'll stand adjourned.
I'm the one that has the evidence the police need to hear. I have evidence this chief needs to hear.
This is not our last meeting. We have another public safety meeting, in fact, in another week. Thank you very much, and we'll stand adjourned.